Hi, I wanted to welcome you to the Divorce Planning Podcast. I'm Carri Goldring, and I'm in the mortgage business, and I do planning pre-divorce for people who are either going to refinance their home, do an equity buyout, or plan to purchase a new home and make sure that everything in the divorce decree is worded properly and the numbers in the planning is taken care of so that you can go through the underwriting process smoothly. And I would like to introduce you to other people who are interested in the divorce planning process so you can get a real education of what's involved. Hope you enjoy.
Today I have with me Attorney Kyle Quinn, and we have a really interesting subject that seems to be very popular right now, talking about mortgage assumption. And Kyle, I wanted to welcome you and say thank you for doing this topic with me.
You're very welcome, Carri. It's a pleasure.
So I had met you because you did a talk on mortgage assumption, and I thought it was great that you agreed to be on the podcast and explain it to my listeners. So I thought maybe to start with, we can just even explain what is an assumption. If someone says, I want to assume my mortgage, what are they saying?
Well, if somebody says, I want to assume the mortgage, that's somewhat of a loaded question with that. But boiled down to its essence, it's I want to keep the mortgage at the same rate, same terms, same balance, and drop off the other party and have him or her removed from all liability under the mortgage and under the note. In its essence, that is it.
I would agree with you. And have you been involved in enough where you've seen success in that, or do you not typically get involved in the whole assumption process?
Well, my role as a practitioner is to, I feel, notify my client about their options that they have. And I can help them pursue that to an extent. And then more often than not, I point them in your direction or others' directions who have more experience and are more, I guess, in the trenches, if you will, dealing with those on a day-by-day basis. But there are some buzzwords that you can give your client to help with that when they pick up the phone. First place, look at the closing documents. What does it say in there? That's your contract that controls. Mm-hmm. And if it doesn't address it, or even if it closes the door, at least at first glance, pick up the phone. Have the client say to the mortgage company, I'm going through a divorce, key word, and I want to speak with somebody about the potential of an assumption.
Okay, then that's interesting so this will be a good topic, because I usually tell people not to say they're going through a divorce when they call about the assumption, because I feel like the person on the other end of the phone hears the word divorce and then they immediately think simple assumption, and then they don't take it farther enough to do the qualified assumption.
Well, that's when more questions need to be asked. I think the divorce is a key word because I don't know if we'll get into this, but there's that due on sales clause, which is typical with a mortgage contract. And saying that key word, I'm going through a divorce, is one of the exceptions for that. And I typically tell people, yeah, if they think it's relevant, say divorce. More often than not, when my clients have called on their own accord to say, I want to talk about an assumption, the response they typically get in return is, nope, that's it. And I've found they've had a little bit more success when they say, I'm going through a divorce, and then I'm getting the house, and I want to speak with somebody about an assumption. If they can specify qualified assumption, that's what we want. They should do it.
Yeah, I think that's what makes it difficult. Usually to do the qualified assumption, you do need the judgment. So the divorce part does come up. But I always feel the hourly wage, person on the phone, once they hear that word divorce, it's so hard to switch them to the assumption that we want them to think about, that I have more success not saying it, but I get where you're coming from the due on sale clause, which I think would come up in the end when all is said and done. So I guess maybe I should have you explain the difference between a simple assumption and a qualified assumption.
Okay. Well, as indicated, those two types of assumptions. A simple assumption is basically just one party that's keeping the home assumes the mortgage. Uh, it does not release the other party from personal liability under the note. A qualified assumption is the party keeping the home takes over the mortgage, same rate, same interest, same balance terms, and the non-owning spouse is released from personal liability under the note.
Okay, and then you and I just talked about, and maybe I'll have you explain this, how does somebody know they were released from the note?
My experience, they typically get something discharged, stamped paid in full on the note from the lender, communicating
Right.
that their liability is no longer on that. And they could see that on their credit report, I assume, as well.
Yeah, and some people don't know to look for that. Like they know to say, okay, I need this assumption. They go through the paperwork, but then the other person doesn't know to watch out for that promissory note to come in the mail saying paid in full. You are released from liability.
Yeah, I think representing the non-owning spouse, your focus needs to be uh, laser on release from personal liability under that note.
Mm-hmm.
That is the most important thing for your client, the non-owning spouse. And just, oh, we're released from the mortgage. Well, that's not enough. The
Mm-mm.
mortgage and the note are two different documents carrying two different responsibilities.
Right, right. And I think that most important part gets overlooked because you're not working most of the time people aren't working with their attorney after the fact. So this is kind of one of those left in the wind things, and then it never gets that final conclusion. And
Yeah,
you're
I
really
would
good
agree.
about being laser focused on what has to happen, but I don't know that most people stay in touch with their attorney after.
Yeah, I would agree with that. And I think they look at their judgment and they say, okay, I get the house and I just have to remove his or her name from the mortgage. And some judgments don't even say the note. They
Right,
just say removed or released from the mortgage.
right.
Well, okay, a simple assumption would qualify for that, and you'd be in compliance with the judgment. But that's a big problem if you represent the non-owning spouse because they're still essentially indefinitely on that note and the personal liability. If a payment's missed, their credit gets dinged. If there's a shortfall at a foreclosure, they can come after them under the note.
Right.
Uh, those are big, big problems.
Right. It's so true. And there I never read consequences in divorce judgments like if this doesn't happen, this happens, or I'll follow up with people after the fact and say, okay, I know your divorce judgment said you had to assume a refinance, you had a year to do it, it's been a year, did you do it? And I usually try to follow up so if they hadn't done it, I could, hopefully help them with the refinance process. But there's many of times where I hear, oh, I talked to my ex-spouse, we're just going to leave things as is. And to me, that's not so great.
Yeah, I would agree. Not so great. People make bad decisions all the time.
That's true. That is true.
Yeah, very true.
Yes. And then you showed me something today too where someone's almost filled out like paperwork and said, "Here, look, I did this simple assumption you're released." But then you obviously noticed that maybe this homeowner wouldn't notice is that it was between the two spouses. It wasn't even written between the mortgage company.
Yeah, I shared with you a titled Release of Liability, two-page document I got uh, forwarded to me from my client that he had received from his ex. And it's relation to a credit union, so I don't know how those rules differ from a normal bank, but it was simply, I hereby agree to release this person from the mortgage. Sign here. This is the name of the property. And my first thought on that was, okay, who's going to honor that? Where's the release of liability under the note? There's not even a line for the bank representative to sign on the document.
Right, it was just between the two spouses or ex-spouses.
Yeah, and I think that could classify as what we talked about as simple assumption,
Mm-hmm.
right?
Mm-hmm.
Uh, but since in this case I represent the non-owning spouse, the spouse that's not getting the house, I want him off all liability under that note.
Right.
And the only one that can do that is the lender.
100%. 100%. No, yeah, a lot of people miss that.
Yeah. Yeah, as we were talking about before, like I've seen countless judgments that just say so and so will refinance the home. Well, I don't really want to be pigeonholed into refinancing if you can do it some other way, or just remove the name from the mortgage. That's insufficient on so many levels. You need to make sure that you're really doing your due diligence to protect your client on that stuff.
Right. And
Because,
I'll tell you on my end, when someone purchases a home and they sign a purchase agreement, the document that's labeled mortgage, the one that gets filed at the county, has to match the purchase agreement. So it's matching the owners, not who's liable for the loan.
mm,
So people use that word mortgage in like a roundabout way of we're talking about the loan and what's due, but in reality, as you know, the mortgage is just the document that gets filed at the county saying, hey, there's a lien on this property.
yeah, I think that's absolutely true. I think a lot of people just knee-jerk reaction, assume it's all grouped under this title of a mortgage.
Right.
But it's not true. Ugh.
Right. Or they'll ask to see a copy of the mortgage, and then somebody gives them a copy of the mortgage and has both names on it, and they say, oh, both names are on the mortgage. Well, no, that means both names were on title at one point in time.
Yep. Yep.
And
Very
there
good
could
point.
have been a deed that was done in the meantime. And
Yep.
then didn't you have some instances when you were doing your research where someone, a bank or a lending institution, agreed to an assumption, but they wanted to change the terms a little bit?
Yes, they had in the case that I was thinking about, I'm trying to find my notes for this. They required, I want to say, almost a closing cost to be a percentage of the
Was it the loan amount?
yeah, the balance of the loan amount for them to come to table with some cash for that. And one of my partners had that happen, and it was a pretty sizable amount. Like if you can think about, okay, you can do this qualified assumption, but one of our conditions that we're placing on that is 5% cost for the principal balance of the existing mortgage.
Right. So it has
5%
to
of a
be
$500,000 mortgage is a lot of money.
right. It's not cheap. And then because when you do the assumption, most lending institutions won't even look to see if it's possible until after there's a judgment signed. So there's no way to even know that somebody would qualify to assume the mortgage until after the fact.
Yeah, I think usually counsel clients to try to do their due diligence ahead of time because that can make a big decision as to whether or not are we going to take a position to keep the house? And the first place to look, as we talked about at the beginning of our discussion, is those closing documents. Does it say that this assumption is even allowed? If it is, I think you can move forward and engage in those discussions with the lender. Uh, I've had a lot of clients over the last year or two that have on the back end, once they have the judgment, and they have to move forward to get the other party removed from liability and off the mortgage, they start that assumption process. And it takes a long time, far longer than a simple refinance.
You might know why it takes so long.
Yes, I do.
It takes a long because when you think about when you apply for a mortgage, you have a salesperson, right? You have someone like me
Yeah.
who's saying, "Hey, I need your bank statements. Oh, you sent me one, but it's missing a corner. Send me another one. I see page 1, 2, 3. I don't see page 4." So you have somebody hand holding and pulling, right, throughout the process. So when you do an assumption, now you have an hourly worker who has a 9 to 5 job, and they send you a list of what's needed. Nobody follows it. I've never once given someone a list of what they need to give me and I get exactly what I want back. And then they get it and they say, "Oh, I asked for W-2s for 2024, but I got 23." And then they put it aside and they don't do anything. And then
Yeah.
2 weeks later, someone calls and says, "Hey, what's going on with my loan?" And then they pull it out of the pile and they say, "Oh, I needed your 2024 W-2 and I don't have it." "Oh, okay, I'll send that in." Okay, put it aside. And now it's January and you send them the W-2 from 2024 and they pull back the file and they say, "Oh, well, W-2s for 2025 are out now. I don't have the right document." And they put it aside again.
Yeah.
And then
Yeah.
2 weeks later you call again. And then according to like our mortgage rules, everything has to be dated within 30 days. So if you give the wrong thing and then you say,
Yeah.
"Oh, well, now I need page 4," and they say, "Well, it's blank. What do you need page 4 for?" "Well, because it says page 1 of 4, so I need 4. I don't know it's blank until you show me." And then by the time they get it, another bank statement's due.
Yeah.
So then they put it aside again. So that's why it takes so long, because you don't have that salesperson in the middle getting all the documents together.
Well, that's a really good point and a really, I think, practical way to look at it. Because I like from my seat, uh, I've seen this regularly take months and months and months, and it's not uncommon, like north of 6, even if not longer.
Mm-hmm.
And one of the big provisions we typically put in a judgment, a divorce, is when this needs to happen. And if you put in there it needs to happen within 60 days, good luck. Uh, Even 90. That's really, really pushing it. And Carrie, I think I've even sent some people in your direction, even though they're working with assumption departments at different banks, to kind of help them and handhold them
Mm-hmm.
with this. You need to get these documents as opposed to being wholly reliant upon the lender to be that point of communication.
Right. And you don't know what you don't know. So you don't know to follow up and to ask questions. When I got divorced, I did an assumption on my loan and saw firsthand.
Yeah.
And because I'm in the business and I huck people for a living, right? So I called, "Did you receive my bank statements? Is there anything else that you need?" "Yes, you need to see I liquidated my IRA according to my divorce judgment," or whatever. "Okay,
Yeah.
which documentation? What exactly are you looking for?" And I knew to ask the questions. I think my assumption took 2 months, which was long but not crazy. But that was with me making it my full-time job like I do for anybody else.
Well, and you have this background and
And I
wealth
have
of
the background.
knowledge already with it that the normal Mr. and Mrs. Mrs. Smith don't have.
Right. So it's it that but that's why it takes so long, because it would be like getting a mortgage with the help of AI. You know, you apply online and you submit your documents and you wonder why it never comes together, because unfortunately you need that pushing person in the middle getting things done in a timely fashion. And then mistakes happen, right? Because then you spend money on something else, or you said you didn't have a liability, but now every bank statement shows that you're paying something, and then they start questioning where's the liability. So the longer it takes, the more room there is for errors. And even on my end, you know, I'm working with a lady right now who's super, super busy. I keep bothering her every day. I need your W-2, I need your W-2, and she never, ever, ever sends it. Well, something else is going to come up because
Well, she's going to get her 2025 W-2.
Right. So I should start asking for that now, actually, because that's probably what's going to happen and then you know, so, you know, it's constant teeth pulling always.
Yeah. Yeah.
So
Very true.
it's interesting. Well, anything else that you can think of that we should add?
Well, one thing I do want to specify with the assumptions is if you can do it, it's great. When you represent the spouse keeping it, it can make a big difference as to whether or not that house can be kept or it needs to be sold, or even the other party gets it if he or she wants it. But the important takeaways with it are you don't get to pull more money out. Uh, that's a big thing. Uh, Typically, in a divorce case, a marital home, it's not uncommon to be the largest asset, the equity in that. And if a party is getting the marital home, and let's say there's $100,000 in equity in that, irrespective of all of the other assets, debts in the estate, they would owe the other spouse typically, let's say, $50,000.
I'm so
Well, where's
glad
that
you
going to
brought
come
that
from?
up.
Is it going to come from the equity in the house? Well, they can't assume it and take more money out.
Right.
You can only assume it with the same rate, same balance as it was before. And if they can't, their finances don't allow them to pull any more money out to get a new mortgage or even a HELOC, well, then that may put the home outside of their reach. Although they may want it, the reality of can they keep it it may be different and not a wise financial decision.
I'm so glad you brought that up. And then the home equity loan interest rate is normally higher than regular interest rate. So depending on what you owe and what you need, sometimes you're just better off doing a refinance. And sometimes
Yeah, that might be it. Because you have to think about all these different moving parts with that. And yeah, that's a big one, big takeaway for me.
Yeah, no, I'm so glad that you brought that up. Very, very important. I thank you for your time.
You're very welcome. It was a pleasure.
It was amazing. If anyone wants to get a hold of you, is there a phone number, website they could use?
Yes. As Carrie indicated, my name is Kyle Quinn. I'm a lawyer at McShane Bowie in Grand Rapids, Michigan. My phone number is 616-732-5000, and email is kjq@msblaw.com.
Wonderful, wonderful. Well, I thank you. Really, really appreciate you doing this.
All right, it was a pleasure.
I hope you enjoyed the podcast. I'm Carri Goldring, and if you ever have any questions regarding mortgage, feel free to give me a call or send me a text message, 248-420-4524. Hope you enjoy the rest of your day.